Okay, welcome. In this lesson, I'm going to teach you how to prepare Form FL100. I'm going to provide you with step-by-step instructions on how you should fill out this form, and then on our web page in which this form is located, I provide a sample petitioner, William Richardson, and I show you how he fills out the form based on his marital information. Please always watch the video first and then refer to the sample on the web page. So let's get started. In the top header of the form, you're going to insert your first and last name, your address, the city in which you reside, the state's going to be California, and then insert your zip code. Add your telephone number, your email address, and in the attorney for field, you're going to put petitioner pro se since you'll be representing yourself in this divorce. Next, you're going to insert the county in which you reside. I reside in San Diego County, so I put San Diego. Here, you're going to insert the address of the court in which you're going to be filing for divorce. Based on my zip code 92114, I would put that I'm going to be filing my divorce in the Central Courthouse, so I use 1100 Union Street. The mailing address is the same, and in most cases it's going to be the same throughout the state for different counties. And then I'm going to insert the city, or you'll insert the city and state and zip code of the court. The branch name in which 1100 Union Street accepts family law filings is the Central Courthouse. And then you'll put the family law division because that's where you're going to be filing this petition for dissolution. And the petitioner field, you're going to put your first and last name. And then in the respondent field, you're going to put your spouse's first and last name. Once this initial petition is filed with the court, it's going to be date stamped. It's going to be date stamped in this area. And then you'll also receive a case number, which you'll insert on subsequent filings as far as your financial disclosures and your final judgment documents. So this is a petition for the dissolution of marriage, so the first two boxes are going to be checked. Your legal relationship is that you are married, so you're going to select box 1A. Here, you'll either have to select whether you or the respondent meet the residency requirements to file for divorce. Next, you'll insert the date in which you were married, the date in which you the date in which you separated. This is the date in which you communicate to your spouse you no longer want to be married, you're seeking a divorce. Sometimes this is the date you move out of the marital home. If you are still residing in the marital home, you need to affirmably tell your spouse, I am seeking a divorce and this marriage is over. That is the date you're going to put as the date of separation. So in this example, I put the date of marriage was January 1st, 2005. The date of separation, February 14, 2010. So time from date of marriage to date of separation will be 5 years, 1 month. And the next section, minor children, you'll either select whether or not you have minor children, and if you don't, you're going to select 4A. If you do, you're going to select 4B and enter your child's first and last name. And you're going to list the first and last name of all your children, their date of birth, their age, and sex, etc. If you need more space, you're going to select box 4B1, and then you're going to attach attachment 4B where you list the rest of your children's name. In this field, it's going to be your first and last name. And then in the next field, it'll be the first and last name of the respondent. The legal grounds of divorces in California are often irreconcilable differences. It's rare that The legal grounds for divorce will be permanent legal incapacity to make decisions. If your spouse has been declared legally incapacitated, then you would select 5A2 instead of 1. If you do have children, you are going to complete item 6. You'll say who you want legal custody to. Usually both parents want to be able to make legal decisions on behalf of their child, such as the medical care they receive, the religious instruction they receive, or what schools they go to. So you can put joint legal custody, but if you are in a situation in which you solely wanted to be the person to make those decisions for your child, you're either going to select one or the other. If you're the petitioner, obviously you're selecting the petitioner, but don't be surprised that when the respondent completes FL 120, the respondent might select that they're the ones to receive legal custody. Don't be surprised, however, in uncontested matters, you should already have discussed that with your spouse before completing this form, but if there's something that you guys need to discuss later as one of the issues working out your divorce, then by all means, you can always amend this petition. But just because you only select yourself for now doesn't mean that in your final judgment you can't have joint legal custody as part of the marital settlement agreement. So physical custody refers to who the child resides with. Say for example, your child is going to primarily reside at your residence, then you would select 6B and then select under the petitioner. However, if the child is likely going to be residing with both of you guys, then you can select joint. Child visitation refers to in the event the child is primarily residing with one parent and the other parent does not see the child as frequently, then in this case, for example, if the child primarily resides with the petitioner, the respondent will have visitation time, and that's going to be captured on Form 311, which is another lesson in which I explain how to write out your child custody visitation schedule. Again, if you do not have children, you can skip this section. This section, there's nothing to complete here, but definitely review what it says in regards to the payment of child support for both parents. This section, you're going to complete this section if you're seeking spousal support. If you're not seeking spousal support, you can skip this section. So if you're the petitioner and you want to receive spousal support, you're going to select 8A and then petitioner, spousal or domestic partner support payable to petitioner. You can also ask the court to terminate the court's ability to award spousal support to the respondent, or you can ask the court to reserve for future determination the issue of spousal support payable to the respondent. So you're not going to select B and C, it's going to be one or the other. And the example of you not wanting spousal support, and you don't want to, and if you don't want your spouse to receive spousal support, you're going to select 8B and then petitioner and respondent. Separate property. Here you're going to list out whether or not you have any separate property you want to claim as part of this divorce. If you don't own anything, then you'll put there are no such assets or debts that I know of to be confirmed by the court. But most people do have limited assets. If that's the case, you're going to select 9B and you're going to ask the court to confirm as separate property the assets and debts either in FL 160 or the following list. So I'm going to show you two options here. So initially, you're going to want to request for all your assets that you acquired pre-marriage, after separation, and during marriage by gift, devise, bequest, or ballot transmutation, and all accumulations to or traceable from said separate property to be confirmed as your separate property. Now, after you file the petition for dissolution, if you do not receive a response from the petitioner, then what you're going to do is you're going to amend your petition for dissolution. Now when you amend your petition, this information is going to be the same. Petition 4, you're going to select amended, petition for dissolution of marriage, and then everything else in this form will likely be clear because again, you're just amending in FL 160. So in that case, you're going to select property declaration, and the language here will be removed. You will attach FL 160 to your amended petition, FL 100, and file that with the court. Make sure you select 9B, confirm as separate property, and then property declaration FL 160. Now, if you know for sure your spouse is not going to respond to the divorce petition, or if your spouse has already told you that he or she will work out a marital settlement agreement, but they're not going to be filing that FL 120 when you initially file your petition, then go ahead and select 9B, confirm as separate property the assets and debts in property declaration. Again, you're going to insert your first name and last name here, and then you're going to insert the respondent's first and last name there. Next, you need to identify your request regarding community and quasi-community property. Now, if you had a short-term marriage, there is the possibility that neither you or your spouse acquired any debts or assets while you're married. If that's the case, you're going to select box 10A. However, most people do acquire some asset, even if it's, for example, a car, a new bank account, etc., or debt, say you take out a loan together, then you're going to have to include that into your divorce as to how both parties are going to divide those assets and debts. So in this case, you're going to select 10B and then as follows. So this language right here is usually included for default or uncontested divorce petitions, and that's because you in good faith are going to try to reach a mutual and equitable settlement of all community and quasi-community property. So community property is the property that was acquired, assets and debts, for example, while you were married, and quasi-community property refers to property that was acquired by both spouses outside the state of California while married. Now, you can amend this petition as previously stated, and when you amend this petition, you're going to remove this language in your amended petition, and you're going to select form FL 160, which is a property declaration in which you request certain assets and debts to be assigned to one party versus the other. For other requests, you can request attorney fees, and then you can also request whether or not you want your former maiden name to be restored. And if so, you would put your maiden name here. Last but not least, make sure you read the restraining orders on the back of the summons, which is FL 110, and then also know that those restraining orders are going to be applied when you file the petition for dissolution. You'll need to ignore this field right here. You're going to need to put your first and last name, type or print, and then you're going to sign this petition. And that is the end of this lesson.